I'm speaking on behalf of these groups today in opposition of the right to work legislation. A point that I believe is very important is that this bill impacts negatively my rights as a business owner to make a determination as to whether or not I want to enter into a collective bargaining agreement with my employees. I think that the statement that was made of Missouri being a forced union state is a misnomer. There is no requirement in this state that an employer enter into a collective bargaining agreement. That's evidenced by the market share that we hold. In the St. Louis region, union electrical contractors hold approximately a 55% market share. That means 45% of those contractors are non-union contractors, and they have 45% of that market share. Clearly, Missouri is not a forced union state. How does right to work create jobs? That's a question that I have. If we already have a pretty even mix of union and non-union employers in the construction industry, and we only have 10 to 15% union employers, union members statewide, that leaves 85 to 90% of the employees in the state of Missouri that are not represented by unions. If they're not represented by unions, then how would right to work create more job opportunities in the state of Missouri? I think specifically in construction, it creates opportunities on the backs of those employers that have been in this state for years. My company's been in business for 70 years. If we have right to work, I think what's going to impact is we're going to have a lot of non-resident contractors coming into the state and taking those construction jobs and bringing employees in from out of Missouri who are going to leave with those wages that we've paid them, pay their taxes in other states. Who does right to work help? That's one of the questions I've had. It doesn't help the existing employers that have chosen to be union employers, as I have. It doesn't help the open shop employers because they've already chosen to be open shop and they don't have union agreements. And how does it help a new business that's starting up or has an organizing effort? No one is required to agree to a union security agreement. There's no requirement for that. So as an employer, I am not required to bargain that into an agreement with a union. So I don't know where the positive impact of right to work lies. The current law, as it is, allows me as a business owner to make a decision. We have decided to be a union contractor for a number of reasons. One is we have a ready, available, trained workforce available to us. Construction is very cyclical. We know that construction unemployment in Missouri now is probably close to 18 to 20%. But we've got the opportunity. School projects traditionally happen May, June, July, and August. In May, June, July, and August, I pray that me and a whole bunch of other contractors are going to need to increase our workforces. The union, having that union pool of labor that's well trained, that I can hire somebody day one and know that they've got a minimum level of skill and experience to get the job done and get the job done safely, I can afford to take that work and go in and say, you know what, I may only have you here for 4 months, but I know I'm going to get the production, I know I'm going to get the safety, I know that the quality is going to be there, and the ability to ramp up to handle that work is very important to me as a business owner. Otherwise, I wouldn't be able to take advantage of those opportunities as they come. Another point I wanted to make, having listened to Senator Ridgway talking about the right to work and non-right to work states. One of the examples that she gave was Tennessee. In Chattanooga, Tennessee, they built a new VW plant. That VW plant was built by IBEW Labor. It was built in part by Sachs Electric in Fenton, Missouri. VW brought Sachs Electric from Fenton, Missouri down to Chattanooga to team with a contractor in Chattanooga, Lawson Electric, happens to be a member from my peer group, to build that plant because they do not have the ability and the skill and the knowledge in that workforce to meet the standards that VW required for that plant. So a Missouri contractor went and built a plant in not in a right-to-work state. I think that's a very important thing for us to understand. As contractors, we contribute to the training of our employees and our apprenticeship programs. Those apprenticeship programs are fully funded by the contractors and by the union. There is no funding that comes from the state, from local government, from the federal government for those programs. We fully fund those. We fund those in order to provide that ready, available, trained, safe, quality workforce. If I don't have access to being able to train employees along with the other 120 signatory contractors in IBEW, that's a huge expense that I, as a contractor, am going to have a hard time doing. I will not be able, on my own, to replicate the training that, as a group of contractors, we are able to provide.
Ma'am, Ron Gladney, I am here on behalf of the Missouri State Labor Council and Missouri State Building Construction Trades Council and IMPACT, which is a joint labor management trust nationwide of iron workers, structural steel folks, and their labor unions. I'm also general counsel for the Iron Workers International. I practiced labor law and pension law for 30 years. When I started, I had a full head of hair. So I think I've actually know some of the answers. They are sometimes a little murky, but as you have those answers, which I heard, or those questions which I heard earlier today, I'll attempt to address them. First of all, the issue of forced unionism. There is no such thing. Period. End of story. Case decided by the U.S. Supreme Court in 1988, CWA versus Beck, Communication Workers of America versus Beck, stands for the proposition that a union security clause, a clause that says all employees after a certain number of days must join a union. Actually, what they said, what that means is not union membership, and leave it to the Supreme Court to say must join a union doesn't mean must join a union, but it's still the law. What it means is they must pay that portion of fees, if there's a union security clause, of dues that are used to represent them. So the portion of dues that are used to negotiate their collective bargaining agreement, to administer their pension plans, to process their grievances. If someone wants to opt out and be non-Beck, they are therefore not a member of the union, but they're still represented by the union in the bargaining unit. What does not come under Beck? Lobbying activities, political contributions. If I don't like what my union is doing politically, I say I'm going to exercise my Beck rights. We have to even post in hiring halls what those Beck rights are. They can pull out of the union, and then they only pay that portion which is attributable to the representation which they get. Let me give you an example in the construction trades. Hiring halls. Dirty little secret. If I am a qualified iron worker and have never been a member of the Iron Workers Union and I come to a union hiring hall, that hiring hall must process them and must treat them as though they are a union worker. That's the case under the National Labor Relations Act. What does that non-union iron worker have to pay? Whatever the reasonable cost is to administer the hiring hall. There's no free lunch, but there is also no forced membership. And it's worked for years. And we get hit with hiring hall charges all the time by the National Labor Relations Board. Sometimes we win, sometimes we lose, but that's a fact. The idea of members-only contracts, I am glad that the gentleman from the National Right to Work Committee admitted that he didn't know of any. Neither do I. I've negotiated contracts for decades. If I go into an employer and say, hey, I got 3 guys, I want to negotiate a special deal for him, that employer doesn't have to negotiate with me. He has no good faith bargaining obligation. You know what that employer is going to tell me? Take your sack lunch out on the street and get off my parking lot. Without exclusive bargaining representation, There are no collective bargaining rights. That's what the National Labor Relations Act protects, is exclusive bargaining rights. And that's why, while they may talk about some theoretical members-only agreement, believe me, as the guy who's negotiated these contracts for 30 years, I've never heard of one. Never heard of the concept until about a week ago. It does not exist. You know, I was born in Columbia, raised in Kansas City, have lived in St. Louis for 20 years, and in the last 10 years in Cape Girardeau when I'm back home. Missouri is a very diverse state. I get that. Sixth-generation Missourian. I get that. I get that some folks in the boot heel are scared of unions. I understand that. Very few organizing campaigns have occurred in the boot heel in the last 20 years. I think organized labor gets it too. The boot heel doesn't want St. Louis unions forced down their throats. Well, guess what? St. Louis doesn't want boot heel views forced down their throats. That's why we're diverse. This anti-right to work thing is all about freedom. It's about allowing employers and unions who have worked collectively together for, in some cases, over 100 years to continue to do that without disruption.
Now, let me take you out of your role and put you in as governor of the state of Missouri. When you have a car company that comes to you and says, I am willing to bring 5,000 jobs to this state, but you're going to have to compete with the states surrounding you. Now, what's the best you can do? And my number one requirement is right to work. Now, in your job as a position of being governor of the state, is it your job to protect your union, or is it your job to move the state forward in a manner that can compete with other states?
Can I answer your question now?
Yeah.
I think my job is to move my state forward, and when I see construction companies of an international scale in St. Louis saying we like it the way it is, and I'm not saying the entire state needs to work the way it did for 100 years, but these guys have been working that way for 100 years. They've been very profitable, and they're a growth industry. Don't shove something down their throat that may not work.
The people in your union enjoy it.
The employers enjoy it.
What do you tell the people in the state of Missouri that want to be part of an auto manufacturing company and have a job at an auto manufacturing plant, but you can't get it because they won't even look at the state of Missouri to relocate?
First of all, I don't believe that. Second, you may have facts I don't have. I don't believe that. Second of all, I'd say relocate in Forsyth or Branson. I'm not aware of a major union organizing effort in outstate Missouri in the last 30 years.
Okay.
And then you got non-union.
We're talking about competing.
Then you got non-union.
You're sitting here with an auto company that's going to bring in 5,000 people, but the number one requirement, you don't make the list unless you're a right-to-work state. Now, how does Missouri compete in that environment unless we become right-to-work?
Senator.
Now, you can protect your union people that are already part of the union, but the people that are striving for that job, you're taking that decision away because they'll never have the opportunity.
Senator, I do not believe there's an auto company in the world that would say we're not coming to Missouri because it's right to work. I disagree with your premise.
When you talk to the experts that I've talked to this summer, when you have testimony from Japanese manufacturing that is the number one requirement to enter a state in the union is a right to work state, that doesn't mean anything to you.
I don't believe it because we've talked to Toyota as well, and they're looking at building plants in non-right to work states. They built their plant in Texas with a project labor agreement. So I just don't believe it.
Texas is a right to work state.
Yeah, but they built it with a project labor agreement.
Yeah, and it's ironic that we lose our manufacturing to a right to work state.
I don't believe that either.
You don't believe that Ford moved their facility to Tennessee?
Because of right to work? No.
Well,
we're just going to disagree. That's why we're Missourians.
Well, you're paid to protect your union, and we're paid to look at what benefits the state of Missouri as a whole.
I'm paid to protect workers, and I'm passionate about my job, and I don't do it for a paycheck, sir.
And our job is to figure out how we, in a global economy, make Missouri a place that people can grow business, that companies can come here and relocate,
Let me tell you,
and
Senator,
be
the
able to
highest
compete with the rest
You
of the
know, guys,
world.
I really
in
appreciate this, and
environment.
this senator is senior to me, but you know what? I'm chair of this committee, and this has been fun, but it's going to end.
the highest
The state here, if you have a place of employment, is an open shop unless you negotiate a union security clause. That is a negotiated thing between the employer and the employees, and the employer certainly doesn't have to do so if they don't want to. If they do, all the employees then will vote as whether or not to accept such an agreement by secret ballot, covered by federal labor law. We don't want anyone in a union who don't want to be there. I've been in the machinist union 47 years, full dues paying member, and I don't want anybody in the IAM who doesn't want to be there. But I want them to pay their fair share, where I'm defending their job when they're fired, when I'm out here negotiating to try to keep their employment, as I did with TWA for years, keeping the carrier in business, out of our pensions and every other way we possibly could to keep people employed that helped this state. And we were the only people that could have helped this carrier remain in business the 15 years I'm talking about. So no one can possibly be required to belong to a union in this country since the Beck decision, as our attorney stated. That's not possible. We do want them to pay their fair share for the services they receive like you would anyone else that you go to for services, whatever they might be. I can bring up study after study, just like the person who flew in here from Washington or wherever they came from, with this idea that came from Washington and the National Right to Work Committee. This is not something that was born in this state. They're doing this in every state in this country, testifying in hearings in every state in this country, flying around testifying, because they want to weaken the voice of workers in Washington, D.C., politically and legislatively, and of course in turn here as well. I'm from here in this state, and we know what's good for this state. We raise the standard of living. The standard of living will decrease about 30% on the whole over a gradual period of time, including all compensation, health care, pensions, wages, and like, between the states you speak of. And that does include cost of living. So we can have the dueling studies. We can have the Economic Policy Institute provide data. We can have the Heritage Foundation provide data. I'm sure there's a grain of truth in either side. The fact of the matter is, this is a matter of employees having a right to determine if they want to be represented. And if they do, and they have bargaining, they don't have to join the union. You need to know that. And last of all, I would simply say that the reason that any of these newly established auto plants have located somewhere else hasn't got anything to do with open shop. It has to do with incentives. Almost every one of those established
To be willing
in
to
those
take a
states
question.
is due to hundreds of millions of dollars of incentives that we cannot compete with. We couldn't hardly get $15 million for Ford to stay here.
Senator
That's
Ferguson.
how come they went to Tennessee and Mississippi and South Carolina. Had nothing to do with open shop. It's